Hi, good afternoon. Thank you for joining us. We're going to go ahead and start. This is the Healthcare Issues and Asset-Based Lending webinar. My name is Tara Robbie. I am an associate in the healthcare practice of Baker Hostetler and based out of the firm's Atlanta office. Our program today will last an hour and is improved for 1 hour of CLE credit in Georgia. Credit is pending also in Ohio and California. For all other states, attorneys can receive a certificate of attendance and electronic materials so that they can file directly with the CLE credentialing entities. During the course of the webinar, we'll share 2 codes that you'll need to enter into a brief CLE questionnaire immediately following the program's conclusion. Once the webinar has ended, please look for a small pop-up on your screen. Click Close for your CLE quiz to appear in your browser. And please make sure to answer all of the questions if you'd like for us to submit for CLE on your behalf. If you have any questions during this presentation, you can type your questions in the bar on the right-hand side of the screen in the questions area, and we'll try our best to answer them at the end of the program, time permitting. If not, we will follow up with you after the webinar to answer those questions. We'll provide our contact information at the end of the program, so you can contact us at any time with comments, suggestions, concerns, or questions. We will also send an email to everyone in the next day or two with a link to a recording of the webinar. So with that announcement, thank you everyone for joining. We'll go ahead and get started. The purpose of today's presentation, The purpose of today's presentation is to analyze healthcare regulatory considerations in negotiating asset-based loans with special attention to loans in the physician dental practice management sector. To also provide practical examples of how to perform diligence related to an asset-based credit facility and how to review an asset-based credit facility for regulatory issues. As an introduction, U.S. healthcare spending grew 3.9% in 2017, reaching $3.5 trillion. As a share of the nation's gross domestic product, healthcare spending accounted for about 17.9%. I'm sure these statistics are not new as they're growing each year. As a result, many financial institutions and investors, borrowers, including banks, independent finance committees practicing outside of the healthcare industry, view healthcare as a fast-growing field ripe with opportunities, mainly because the provision of healthcare services to patients is both growing, but it's also distinguished by a pervasive third-party payer system, specifically Medicare and Medicaid. It's no secret, however, that governmental payer sources such as Medicare and Medicaid are under tremendous cost containment pressure as the healthcare population continues to grow, or aging baby boomers is driving demand, while the Centers for Medicare and Medicaid Services, CMS, is cutting reimbursement and sometimes aggressively to certain sectors. This reliance by providers on volatile government payment programs can impair cash flow and liquidity of borrowers. So, for example, in the past few years, we've seen an uptick in borrower activity among DME suppliers, infusion, home health, all of which have suffered payment and coverage restrictions. This will continue as CMS brings down some coverage restrictions on other types of providers and in other practice areas. For healthcare companies, accounts receivables generally represent a significant asset and therefore present a potentially attractive source of collateral to secure loans or working capital lines of credit. Cash flow-based loan facilities are not an option for many providers who must in turn to asset-based loans predicated on the value of receivables owing to the provider by third-party payers. Regardless of whether a secured lender is lending on an asset-based model or cash flow-based model, however, the secured lender must understand its provider's third-party payer programs, how the receivables under those programs are originated and valued, and how a security interest in such receivables are created, perfected, and enforced. This presentation will address several collateral and legal issues that are unique to secured lending transactions with borrowers who provide medical services or supplies, and we'll refer to them as providers for purposes of this presentation, in exchange for expected future payments from governmental programs or other third-party payers. Now, the first section here provides basic background information on the differences between asset-based lending and cash flow-based lending. When a company borrows money from a bank or another institution to fund its operations or acquire another company or engage in another major purchase, it'll likely finance the loan through one of two primary lending methods, cash flow or asset-based. And asset-based loans, like many cash flow-based loans, are often structured as a revolving loan. A revolving credit loan or revolving credit facility, we'll use those terms interchangeably here, allows a borrower to borrow up to a limit, repay, and reborrow those loans. Cash flow-based lending allows individuals or companies to borrow money based on the projected future cash flows of a company, while asset-based lending allows them to borrow money based on the liquidation value of the assets on its balance sheet. In cash flow-based lending, a financial institution grants a loan that is backed by the recipient's personal or business cash flows. By definition, this means that a company borrows money from expected revenues they anticipate they will receive in the future. Credit ratings are far more important in this form of lending in addition to historical cash flows. So, for example, a company that's attempting to meet its payroll obligations might use cash flow finance to pay its employees now, pay back the loan, and any interest on the profits and revenues generated by the employees on a future date. These loans don't require any type of physical collateral like property or assets. Instead, lenders examine its expected future company incomes, its credit rating, and its enterprise value. Institutions underwrite cash flow-based loans by determining credit capacity. Typically they'll use EBITDA along with a credit multiplier to calculate this figure. This financing method enables lenders to account for any risk brought on by the sector in economic cycles. During an economic downturn, many companies will see a decline in their EBITDA, while the risk multiplier used by the bank will also decline. The combination of these two declining numbers will reduce the available credit capacity for an organization. Cash flow loans are better suited for companies that maintain high margins on their balance sheets or lack enough in hard assets to offer as collateral. The advantage to this method is that the process requires less reporting and exams, and it's generally faster. An asset-based loan is different in that it's no surprise that the foundation of any ABL facility is the asset supporting the borrowing base. Asset-based lending is a business loan secured by the liquidation value of the assets. A recipient receives this form of financing by offering its inventory, accounts receivable, and other balance sheet assets as collateral. Common assets that are provided as collateral for a capital loan include physical assets such as real estate, land, physical properties, company inventory, and manufacturing equipment or physical commodities. If the borrower fails to repay the loan or defaults, the lending bank can seize the collateral and sell the assets in order to recoup its loan amount. Unlike a cash flow facility where lenders look at the borrower's future cash flows, availability of a loan in the ABL facility is driven by the quality and the value of the borrowing-based assets, which is typically eligible inventory and eligible receivables, and sometimes eligible equipment. Borrowing-based percentages usually range from 50 to 95% based on the type of collateral, with larger percentages being lent on assets with higher turnover and liquidity, such as accounts receivable. ABLs maintain a very strict criteria of assets which may be included in the borrowing base. An asset-based lender is better suited for lending is better suited for organizations that have large balance sheets, lower EBITDA margins. There are also companies that require capital to operate and grow, particularly in industries such as healthcare, that might not provide significant cash flow potential. An asset-based loan can provide a company the needed capital to address its lack of rapid growth. Asset-based loans maintain a very strict set of rules regarding the collateral status of the physical assets being used to obtain a loan. Above all else, no company or individual may offer these assets as a form of collateral to other lenders, and should these assets be pledged to another lender, this former loan provider must subordinate their position to obtain the assets. Accounts receivables are the most common asset of a provider that can serve as collateral for a loan facility. The typical accounts receivable financing arrangement outside of the healthcare context is structured as a loan secured by the receivables. In either case, the proceeds of the accounts receivable normally flow through a special account or a lockbox, which may be controlled by either the borrower or the lender. The receivables are typically serviced on a day-to-day basis by the borrower, but the financing arrangement generally authorizes the lender to collect directly from the account debtor in the event of a default by the borrower. Healthcare organizations are unique in that many providers do not own the real property where they practice or the equipment used in the provision of the services. For providers that do not qualify for cash flow-based financing, accounts receivables are often the only type of viable collateral for a secured loan facility. Government healthcare receivables and private insurance receivables are the two most common type of healthcare receivables that are financed by healthcare lenders. Other receivables such as self-pay or capitation payments are often excluded from borrowing-based consideration because of the unpredictable or questionable nature and collectability of the payment obligation. So as this presentation focuses on the principal collateral issues arising when taking a security interest in government healthcare receivables, government receivable valuation, Medicare and Medicaid are the two principal government healthcare programs in the United States. Medicare is a health insurance program for persons age 65 or over, as well as individuals who are disabled. Medicare is funded by the federal government and administered by CMS. Medicaid is the health insurance program for eligible low-income individuals that is funded by the states and by federal matching funds and is administered by the states subject to guidelines established by CMS. The distinction is that certain providers are heavily dependent on Medicare and Medicaid receivables. For Medicaid, we see pediatric dental, pediatric home care, a lot of activity in that space. And then on the Medicare side, dermatology, ophthalmology, practice management, acquisitions, home distressed DME, distressed home health, distressed hospice, long-term care. Unlike a traditional secured loan facility, the principal issue with Medicare and Medicaid receivables is not whether the payer in the United States or the state government will have the ability to pay, but rather the principal issue is whether the governmental payer will pay an amount less than what was estimated or predicted by the provider. And most significantly, the Medicare and Medicaid programs are notoriously complex, and reimbursement rates are subject to change with little notice. As a case example, or a recent case where we're representing the lender, the provider here, or the borrower, was a infusion pump supplier. And in this particular example, we were negotiating a credit facility with the borrower that supplies the infusion pump. CMS released in the middle of the negotiations an MLN Matters publication described as a, quote, clarification, which fundamentally changed borrowers and the industry's understanding for billing external infusion pumps initiated in a physician's office and sent home with the physician. The borrower here actually provided the pumps to physicians who initiated the infusion service at the office, sent the patient home with the infusion pump and the medication, and then the patient would return after the medicine was properly infused. The business model for the borrower would be that the borrower would bill for the pump, and then the physician would bill separately for the medication and for the physician service. After the publication of this during the negotiations, there was a change in the business model because our borrower could no longer submit bills for the pumps, and what was now considered a clarification could now potentially be considered an overpayment on the existing receivable. So in this particular example, it just demonstrates the importance of how you have to keep a current understanding of CMS policy, but also how the value of the borrower base can change overnight and potentially become subject to overpayments. That said, if an audit in most Medicare and Medicaid payments in which a provider receives reimbursables, they can be subject to pending final confirmation by audit. If an audit indicates that the provider was overpaid, the Medicare or Medicaid payer may offset such overpayments against future payments against which a secured lender may have already advanced. Lenders should mitigate overpayment risk by examining historical reimbursements and monitoring the provider's claim preparation process to ensure that it's consistent with customary practice. And while any ABL credit facility is going to give some discretion to the lender to determine eligibility of receivables, it is not uncommon for the lender to have substantial or even unlimited flexibility to modify advance rates, set reserves, often called liquidity factors, and otherwise adjust availability with respect to government receivables. In the context of a cash flow loan, the secured lender is also keenly interested in the provider's historical billing and collections practices and results as a predictor of future cash flows. Under Article 9 of the UCC, a secured party with a security interest in accounts receivable generally has several remedies that it may pursue after default. The secured party may, 1, notify account debtors to make payment directly to the secured party, 2, enforce the rights of the borrower directly against the account debtor, and 3, compromise and settle the accounts receivable in a commercially reasonable manner. However, a secured party with a security interest in Medicare and Medicaid receivables generally cannot exercise any of the foregoing remedies because the Medicare and Medicaid statutes and the Federal Assignment of Claims Act, which ordinarily cannot be complied with for Medicare and Medicaid receivables expressly prohibit the exercise of these remedies. A secured lender should understand that its ability to direct the liquidation of Medicare and Medicaid receivables is substantially constrained. Where Medicare and Medicaid receivables are involved, federal law limits a lender's purchaser's ability to collect payments directly from the government. And ABLs must be carefully structured to comply with federal regulations while also giving the lender assurances that it can collect the account's receivables in the event of a default. The federal Medicare statute contains prohibitions on payments of amounts owed to providers to any entity other than the provider under an assignment, power of attorney, or other direct payment arrangement. Specifically, the Medicare Claims Processing Manual states, carriers may pay assigned benefits only to the physician, practitioner, or supplier who furnished the service. So as a result, Medicare will not pay benefits to any other person or organization under an assignment or reassignment, power of attorney, or under any arrangement in which the other person or organization receives the payment directly. And this is generally referred to as the Medicare anti-assignment provision. As a result, a deposit account cannot be subject to a customary UCC control agreement. Medicare has published policies addressing payment to a bank. Under this policy, Medicare payments due to a provider or supplier of services may be sent to a bank for deposit into the account so long as the following requirements are met. The bank may provide financing as long as it waives its right of offset. The account is in the provider or supplier's name only, and only that provider or supplier may issue any instructions on the account. No other agreement that the supplier has with a third party shall have any influence on the account. And in other words, if a bank is under a standing order from the supplier to transfer funds from the supplier's account to the account of a financing entity in the same or another bank, and the supplier rescinds that order, the bank honors this rescission, notwithstanding the fact that it's a breach of the agreement with the financing entity. Subject to these above restrictions on the bank, the provider supplier's billing agent that meets certain conditions and receives deposits in the bank account may draw on these funds to pay for its billing services. And that's a common exception that's used on those bank accounts. There are other exceptions, and those include payment to a government agency, payment pursuant to a court order, payment to an agent references the payment to the billing agent, which I just described. And those, just for reference, requirements are that the agency agreement between the provider and that there must be an agency agreement between the provider and the agent. The agent's compensation is not related or dependent upon the amount billed or collected. The agent acts under payment disposition instructions that the provider may modify or revoke at any time, and that's similar to the requirement under payments to a bank that we just discussed. And the agent acts only on behalf of the provider when receiving the payment. Other exceptions for payments to employers, payments for services provided under a contractual agreement, payments for anti-markup tests, and payments under reciprocal billing arrangements. Because of the anti-assignment prohibition, the initial deposit account cannot be subject to a customary UCC three-party control agreement, whereby the depository bank agrees to give the lender the right to direct the disposition of funds in the deposit account, even if such right is only exercised after default. Although the statutes and regulations do not prohibit assignments of claims under Medicare and Medicaid, there is a stubbornly persistent misconception that a lender cannot take an effective security interest in Medicare and Medicaid accounts receivable under Article 9 of the UCC. Federal case law, however, and U.S. congressional legislative commentary and the Medicare and Medicaid statutes and regulations themselves clearly permit the assignment or grant of a security interest in Medicare and Medicaid receivables, so long as payments of such receivables are made only to the provider itself. Thus, you can take a security interest and perfect the interest in the receivables themselves. You just can't have a deposit control account agreement with regard to the account that the Medicare receivables are deposited into by the government payer. And in this example, perfection would be like any other deal. File a UCC, get a deposit account control agreement over the accounts other than the Medicare and Medicaid receivables account, take possession of equity certificates as certificated, file a lien with the USPTO on patents and trademarks, and with copyrights if there are any registered. Medicaid assignment. Because Medicaid program is a joint federal-state program, states are given wide latitude with respect to the structure of their Medicaid program. and it's possible that individual state Medicaid programs may contain restrictions with respect to the assignment of Medicaid account receivables that are stricter than the federal guidelines. Accordingly, in determining which states' Medicaid receivables will serve as collateral for the loan, the relevant state statutes and regulations should also be examined. However, it's unlikely that the state Medicaid statutes prevent providers from using their accounts receivable as collateral. Medicaid regulations generally provide exceptions quite similar to those available under Medicare. However, state interpretations may vary from the federal standards. So, for example, California does not permit payments to any parties under any circumstances other than the provider, meaning it doesn't have the exceptions that have been set out under Medicare. Okay, other governmental payer programs. One that comes up a fair amount would be the Federal Assignment of Claims Act. Lenders financing healthcare entities that have other types of healthcare-related government receivables, such as energy, Employees Occupational Illness Compensation Program Act receivables, or Black Lung Benefits Act receivables, face similar restrictions on the assignment of receivables under the Federal Assignment of Claims Act. And the Federal Assignment of Claims Act defines an assignment as a transfer or assignment of any part of a claim against the U.S. government or of an interest in the claim, or the authorization to receive payment for any part of the claim. The Act imposes several formal requirements that must be met in order for an assignment of a claim under the U.S. government to be against the U.S. government to be enforceable. Like the Medicare and Medicaid statutes, the Assignment of Claims Act does not affect the validity or enforceability of an assignment between the parties, and instead the Act only limits enforceability against the government. The Federal Assignment of Claims Act contains a financing exception for claims aggregating at least $1,000 in order for an assignment of receivables to comply with the exception. However, the lender must comply with the burdensome notice filing requirements, and the assignment must generally occur as part of the financing and prior to the performance of the government contract. This latter creates challenges in the healthcare industry, where claims are generated after services are provided to patients. As a result, financing institutions often utilize a double lockbox structure for all types of healthcare-related government receivables. To address the inability of a lender to offset against the initial deposit account, or obtain a direct security interest in such deposit account through the use of a control agreement, lenders commonly require a double lockbox structure. And as discussed before, CMS regulations require that all Medicare and Medicaid payments must be initially paid to an account fully controlled by the provider. And therefore, the lender cannot perfect a direct security interest in that account through the use of a control agreement. It's important to note, as we stated before, that assuming the lender has taken appropriate steps under the UCC to perfect its security interest in all of a provider's Medicare and Medicaid accounts receivable, the lender will continue to have an indirect security interest in any amounts on deposit in such a deposit account that constitute identifiable proceeds of the Medicare and Medicaid receivables themselves. Nevertheless, a lender's recourse against such proceeds are severely limited until those funds are moved out of the provider's initial deposit account. And as part of the Medicare enrollment process, providers are required to obtain offset waiver confirmations from their bank lenders for deposit accounts maintained with the bank lender that will directly receive Medicare or Medicaid payments, demonstrating that this is monitored by Medicare or Medicaid as part of even the enrollment requirements of the provider. As a result, until those payments are moved into a different deposit account at the direction of the provider, bank lenders are unable to sweep or offset such payments unilaterally. Healthcare lenders generally mitigate the risk of not having control over the initial deposit account into which those payments are made by utilizing the structure known as the double lockbox arrangement. And the goal is to move those payments as quickly as possible from the first tainted deposit account into a second deposit account that is not subject to CMS restrictions on the non-provider having control. Under this double lockbox arrangement, the provider instructs CMS and all other applicable government payers, but not its insurance payers, to make payment to a dedicated government receivables deposit account. The government receivables deposit account should be subject rather, to a modified three-party agreement that resembles a traditional deposit control agreement in all ways except that the provider retains all rights to direct disposition of funds in the account in order to comply with the CMS regulations and, by proxy, CMS enrollment requirements. This three-party account agreement should also provide that the depository bank waives its rights to set off other than for customary account charges and returned items, so that the lender is not competing against the depository bank for priority and amounts on deposit in the deposit account. And finally, the three-party account agreement should also provide that the provider voluntarily instructs the depository bank to sweep the government receivables deposit account on a daily basis to a second deposit account over which the lender has control through a traditional control agreement. While the provider must retain the right to rescind the daily sweep instructions to the second lockbox at any time in order to comply with CMS regulations, the loan agreement should provide that exercising such rescission constitutes an immediate event of default under the credit facility agreement. The lender should be able to determine whether such unauthorized redirection has occurred by monitoring cash flow in both of the two deposit accounts. Note that the CMS regulations do not prohibit a provider from giving a lender electronic access to review deposit account balances. If a provider were to breach its obligations under the loan agreement and stop automatic daily sweep of funds to the second deposit account, only a few days of collection should be impacted before the lender would discover the breach and be able to call a default and stop funding additional loans, and presumably enter into workout discussions with the provider or exercise remedies against the provider. CMS has approved this double lockbox arrangement in policy statements and in private decisions. In a scenario where the lender is also the depository bank for the provider, a modified form of the double lockbox arrangement is recommended without the need for a three-party agreement. Now we're going to talk a little bit of the process leading into the credit facility agreement. And the first is going to start with due diligence. And prior to authorizing a loan, lenders require a relatively lengthy due diligence process, which includes the inspection of the balance sheet, ledgers, and assets to calculate value of the company's allowable borrowing capacity. Costs associated with this analysis vary, but common charges include site visits, collateral evaluations, and interest costs. And in these types of facilities, lenders tend to be keenly interested in ensuring that the assets against which it is lending are, in the case of inventory, of good quality, easily accessible, and in the case of receivables, likely to be collected. This focus can lead to detailed reporting requirements, both as to scope and frequency. And for example, a lender might want a borrower to report on a weekly or monthly basis the value of the eligible assets, accounts receivables aging, accounts payable aging, and inventory status report. Diligence category will be similar to those requested for the healthcare diligence. Diligence categories will be similar to those requested as part of a healthcare acquisition transaction, but lenders may also require a diligence memo by a borrower in an acquisition. This focus will lead to detailed reps, warranties, covenants, notification requirements, and events of default. I've set out for you here some common diligence categories, which include payer enrollment and documentation requirements, licenses to operate, federal and state facility licenses and accreditations, individual professional licenses, mandatory background screening requirements, FDA requirements, compliance with licensing and inspection requirements. As far as the receivables, you're going to be looking into enrollment in government programs or private payer programs to receive reimbursement, compliance with government and private payer billing and standard of care requirements, fraud and compliance investigations or audits by government agencies, ongoing investigations, recent settlements, associate requirements. If there are any recent settlements with the DOJ or OIG resulting in a 5-year corporate integrity agreement, the lender is probably going to seek to build its own reporting requirements to stay ahead of the CIA reporting requirements. Any potential disgruntled employees or potential whistleblower actions you'd want to diligence, civil litigation relating to standards of care, and then referral relationships between owners, sales, and marketing staff, physicians, immediate family members, and of course a detailed review of any existing healthcare compliance program. And then also the diligence into HIPAA, but the applicability of state insurance regulations. For example, we had a dental practice in California that structured its dental operations as a dental insurance company to circumvent, or at least to address, corporate practice of dentistry laws. However, the insurance regulations prevented the insurance company from borrowing amounts over a certain threshold and had additional reporting requirements. As a result, the California operations of the dental practice couldn't be a guarantor in the credit facility. So you have to keep in mind unique state law considerations as well when diligencing these items. With regard to the ABL credit facility, this next section goes over just the process and the relevant sections that need to be examined as part of the healthcare, in a healthcare deal. generally you're going to start with your commitment letter or term sheet. You're not going to see a lot of commitments in the lower middle market deals, but a commitment is a commitment to loan money, and the lender has to reserve an amount of capital to get investment committee approval. The term sheet, alternatively, is highly negotiated. For a healthcare review, first we're going to be looking at the definitions, narrowing down healthcare laws to what is applicable, governmental entities that would be applicable, the third-party payers, and what type of receivables are going to be included as part of the borrower base would be relevant to this definition, and their government reimbursement programs as well. The next section that would require healthcare reviews are the representations and warranties, compliance with any healthcare laws. That would be pretty broad or possibly sectioned out depending on how detailed the operations are. Then, importantly, the covenants, ongoing covenants, financial statements and reports, reporting requirements, compliance with healthcare laws, and events of default where you'd build in ongoing compliance or monitoring on behalf of the lender to the extent any issues were discovered in due diligence. So again, here, the reps and warranties, they'd address any governing regulatory framework identified in diligence, compliance with healthcare laws, no healthcare permits, ensure that there's no excluded individuals or entities, any HIPAA issues. The covenants would be the continued obligations during the term of the loan. Again, compliance with healthcare laws, maintaining healthcare permits, maintaining HIPAA compliance. And the notices are going to be highly negotiated as far as time periods and dollar thresholds. I've provided an example here, which is fairly substantive. And I'll read through it. Promptly upon and in any event within 5 business days, that's a negotiable term, of becoming aware of any notice that a loan party or subsidiary currently is or has been subject to an investigation, audit, or claims review by any payer or governmental authority, any charges by a governmental authority or violations of a state licensure law, including or involving any loan party or subsidiary, any receipt of any survey or inspection from a governmental authority that could reasonably be expected to result in a material adverse effect, and that is fairly broad to be built into the notices, and would result in kind of a large reporting requirement on behalf of the borrower. But again, it depends on what sector the provider's operating in, what are the diligence issues and the ongoing investigations, et cetera. Any notice or of loss or threatened loss of governmental approval or accreditation that could lead to a material adverse effect, the imposition of any CMPs. And here are some other additional, becoming aware of any actual alleged violation of any healthcare law. That's fairly broad. The commencement of any material developments in any investigation, inquiry, suit, proceeding, the pending imposition of any fines in excess of $250,000. That again, that dollar amount or dollar threshold would be highly negotiated. Essentially, in the notices provision, you're trying to ensure that any past non-compliance is addressed and resolved. And for example, if a provider had any issues with its facility inspection or HIPAA compliance, a lender may be able to require notices of upcoming or surprise inspections, or a lender may provide a timetable for the borrower to demonstrate it has implemented the appropriate changes to reach HIPAA compliance. And here, in the events of default, you would be able to, again, this would be the ability to customize based on any unique issues you've identified in diligence. For example, if any of the following, here's just a general example, if any of the following shall occur, any material healthcare permit of a loan party shall be revoked, failed to be renewed, suspended, or otherwise terminated, or any loan party or any officer, director, partner, shareholder, or managing employee of a loan party shall have been found guilty of fraud, shall have been indicted for or convicted of a felony or crime related to medical services or services provided pursuant to a third-party payer. Generally, you'd want to build out your notices and not necessarily have those mirror reflect what would be in the events of default for healthcare. Just given the industry, what comes up in negotiations is that you're going to have your 3 types of audits. You're going to have your roving audits. You're going to have auditing based on any known overpayment issues. And you may have just CIA reporting requirements. And given the circumstances of what this loan is, given the circumstances of the borrowing base or of the provider and of the sector, you might want to build in a lot of requirements into the notices and not too many events of default. You may want to mirror them on both sides. I've seen it done in multiple ways at multiple dollar thresholds, but you can see this is the importance of finding the delicate balance and of the negotiations with regard to the healthcare regulatory issues in any diligence items. Now, this presentation is also going to focus on, and this is the final section, of practice management arrangements. And there's been an uptick in the last 3 years in acquisitions in the dental, physician practice management, sectors of the physician practice, specialties of physician practice management, such as ortho, ophthalmology, dermatology, and I've set out here the basic structure of how that would look like and what's generally going to be a private equity acquisition. You have your licensed professional owning, and this is structured, let me just say the preface, structured because of corporate practice prohibitions in the various states in which a borrower, in which a practice management company may not be able to, or a private equity company may not be able to own a practice entity directly. And generally we see it as a practice entity which is owned by a licensed professional, and the practice entity enters into a management arrangement with the management company, and then you have a parent, generally a private equity company, of the management company. The management company would provide equipment, billing, administrative services, real estate, non-clinical staff, non-other clinical services, and it would receive a management fee in exchange for those services. When providing a credit facility for the operation of both the management company and or the practice entity, the lender will want to review the management agreement, the employment agreements between the licensed professionals and the management company, stock transfer agreements or any equity transfer agreements entered into by the professional entity owner, any other agreements entered into with the professional entity owner and the management company, and then any other agreements entered into with the seller and the management company, professional entity, individual professionals in an acquisition. And I'm going to go back to the last slide. The reason that diligence is relevant is essentially determining who's going to be the borrower and the guarantor in this arrangement where there are corporate practice medicine issues surrounding the practice entity. So the general matter, we've seen the management company as borrower, the parent could be borrower or guarantor, and the practice entity may or may not be part of that credit facility. The lender is reviewing those arrangements or the agreements between the practice entity and the management company to ensure essentially that the managed company has sufficient control over the professional entity such that the lender can step in if needed and make any changes to personnel and operations, at least on the management company side, personnel and operations on the management company side. And that need is delicately balanced with corporate practice prohibitions as well. And as a general matter, the parent, as I said before, the parent and management company will be the borrower. The parent will be the guarantor or borrower and will pledge the equity of the management company. There's also provisions built in to ensure that a lender can kick out the management personnel in the event of default and put in their own management team into the management company. And again, perfection is like any other deal. You file the UCC, get a deposit account control agreement over accounts. Other than the Medicare and Medicaid receivables account, take possession of equity certificates that's certificated, file with the USPTO and patents and trademarks, and with copyrights if any are registered. As a case example, and this is possibly the most notorious case example enforcement in a practice management, which is the Aspen Dental settlement agreement with the New York Attorney General's office in June 15, 2015. And the facts of this settlement are fairly unique in that Aspen Dental was accused or alleged to have committed just some gross practice violations, and that there was a civil class actions in multiple states and then also in New York relating to, or at least alleging that some of the dentists were pulling out teeth that shouldn't have been pulled and just grossly over incentivized to build out volume and essentially build out the Medicaid program. And there was a settlement with Aspen Dental and the New York Attorney General's office, which is highly detailed and sets out some very specific requirements as to what the management company can and cannot do with relation to the practice entities, which is the dental practicing entities. And surprisingly, those that settlement agreement, while it does go in such very specific detail, it leaves entirely blank, or it doesn't address the enforceability of what's usually considered lender restrictions or lender requirements on the relationship between the practice management company and the practice entity. So, for example, generally, as described before in the previous slide, you're going to see some safeguards built into the management arrangement to ensure that the management company, to ensure that there's a balanced relationship between the management company and the practice entity. And some of those requirements would be potentially a directed stock transfer agreement or a directed equity agreement in which the management company could replace the owner of the professional owner of the professional entity. You'll also see some termination provisions built into the management services agreement, some terminations built in any employment agreements with any professionals with the practice entity. And the Aspen Dental settlement agreement doesn't address any three of those safeguards that I just described. And it leaves open the enforceability of whether the stock transfer restriction agreements or other practice control agreements would be enforceable. And the reason that's kind of unique in the settlement agreement is because there's a large discussion about how the bank accounts should be controlled. And it was addressed in the settlement agreement that the management company had too much control over the dental practice bank accounts, meaning it could deposit money whenever it wanted, it could take out money whenever it wanted, and it was paying for expenses across the board out of those accounts. And in the settlement agreement, it was required that only the practice, similar to the Medicare requirements, that only the dental practice have control over the account. And there's no discussion over any type of lockbox arrangement in the settlement agreement, and there's no discussion over the other types of safeguards not relating to the account, such as the directed stock transfers or other practice control agreements. So from my understanding is that was intentional, and it leaves open the enforceability of these types of safeguards, which are usually implemented by the lender in the arrangement, as to whether they can be sufficiently enforced. Should there be an issue between the management company or even between the lender and the management company. So with that said, we have any questions, feel free to, I believe there should be an email method to the email, or if not, anybody feel free to jump in and ask a question, unmute your line. Happy to answer any. Okay, no questions as of now. Great. Again, feel free to email any questions, or this will be recorded. Reach out to a personal email, and then I believe Emily Spiller email is at the end. In conclusion, as a borrower, after the deal closes, you'll want to focus on accounts receivables, as the collateral can lead to detailed reporting requirements, both as to scope and frequency. So, for example, the lender might want the borrower to report on a weekly or monthly basis the value of the eligible assets, accounts receivable aging, accounts payable aging, and inventory status reports. These requirements are burdensome for borrowers, many of whom have treasury staff stretched too thin. There are certain ways, however, for lawyers to help their clients build a culture of compliance and to help avoid defaults. These techniques can be employed at the term sheet phase, during the credit agreement negotiations, and throughout the life of the loan. After the deal closes, create a compliance checklist for the borrower that summarizes in layman's terms what the borrower can and cannot do to remain in compliance with its ABL credit requirements, the credit agreement. You want to include regular and occurrence-based reporting requirements, as well as operating negative covenants. Including these requirements can be a valuable tool for borrowers as they navigate the sometimes overwhelming number of obligations contained in ABL credit documents. And further, counsel should consider maintaining a running list of compliance issues raised by clients. This list would be helpful to have before any amendment or refinancing to address any common or recurring compliance concerns. For lenders, you'll continue to see increased investment and payment crunches in the healthcare space. The best positioned healthcare ABL lenders are involved in a wide range of sectors across the healthcare industry and rely on dedicated healthcare lending expertise. I appreciate everybody's attendance here. I left a fair amount of block for questions and answers, but if we don't have any questions, that is okay. And I apologize, like the two codes for the CLE will be as follows. B Baker, H like Hostetler, 123. And the second code would be BH456. Again, thank you everyone for attending. Please feel free to reach out directly if you have any questions to me or Emily Spiller.